Hi guys, welcome back to Prospect Channel TV. Thank you for always coming out here. May God bless you all. Nigerians, this is a very interesting news. Biafrans are rejoicing as the UK Parliament now discussing Nnamdi Kanu's release. Now they don't discuss Nnamdi Kanu's release after he was adopted in Kenya to Nigeria. They know everything that happened. Nnamdi Kanu was adopted in Kenya, even with British passport. Since 2021 to date, they kept mute. Why Nnamdi Kanu, is in DSS custody and all the unjust trial and everything. But well, they say anytime when person wake up, 9 in the morning. Now they are not discussing Nnamdi Kanu's release, okay? They are not questioning Nigerian government how Mazi Nnamdi Kanu was adopted in Kenya. This is after going to 4 years now. You understand? Now, so people did it buy like that, they go. Now they have decided to ask questions. What happened? How he was adopted, and everything that is going on right now concerning his trial. Anyway, guys, I'm going to drop the news for you. Make una see. And you go still here waiting Nnamdi Kanu. Don't tell Nigerian government concerning his trial. So, guys, let's watch the video together.
The UK Parliament says it is now set to commence a debate on the repatriation of the separatist leader. In a parliamentary schedule posted on its website, the date set for the debate is Wednesday, July 7th. According to the document, Lord Alton of Liverpool will be raising the issue at the House of Lords and will query the Nigerian government on the separatist leader's transfer to Nigeria. The British government had said that Kanu, who was traveling with a British passport, was not arrested within the United Kingdom's territory as controversy continued to trail the circumstances and where Kanu was repatriated from. In another development, Kelechi Madu, the Minister of Justice and Solicitor General of the Government of Alberta in Canada, has slammed the Nigerian Minister of Justice on attorney arrest of the IPOB leader. In a post on his LinkedIn page, Kelechi wrote that if reports that Kanu was abducted were true, Malami was not only a disgrace to the rule of law, but was also not worthy to be a public officer, and called on world leaders to apply appropriate sanctions on Nigeria. Well, there are two sides to this story. The Nigerian government will argue that Kanu is a Nigerian, and we as a sovereign state have the right to treat their citizen in the manner which they deem fit. But you know that Kanu is also a British citizen. And so
if we really know what we are doing, I think that man, Abubakar Malami, the former AGF of Nigeria, supposed to at least tell Nigerians waiting make him do waiting he do. You understand? What made him to do what he did? Because this is a man that has been discharged and acquitted. He said, no. Look at what is happening today. The way they are going about the trial. It be like child's play. Make una watch waiting. Courts don't talk before now. Nnamdi Kanu has been discharged before. Now still the same Nigerian court. Make una hear them. Talk am. Not be my mouth.
Its judgment discharging Mr. Nnamdi Kanu of the 6-count charge of terrorism on the grounds that the trial court lacked the jurisdiction to entertain the charges against him. The court held that an unlawful and extraordinary rendition without adherence to due process of the law is a gross violation of all international conventions, protocols and treaties that Nigeria is signatory to, as well as a breach of the appellant's fundamental human rights. The appellate court holds that the federal government failed to controvert the allegation that the IPOB leader was abducted in Kenya and brought back to Nigeria without extradition proceeding. The court further adds that the government was ominously silent on the issue, which is described as very pivotal in determining whether the trial court will still have the jurisdiction to continue with the criminal proceeding before it. The court also notes that Nigeria is a signatory to African Union Convention, which it ratified on April 28, 2022, as well as the Charter on Human and People's Rights, which it said prescribed how a wanted person could be transferred from one country to another through an extradition request, which must be in writing with a statement indicating offences for which a person is wanted. The appellate court held that the government's action tainted the entire proceeding it initiated against Mr. Nnamdi Kanu and amounted to an abuse of criminal prosecution in general. Although the counsel to the federal government left the court immediately after the judgment, the lawyer to Mr. Kanu reacts to the judgment.
There was one fundamental issue on which the court today anchored its judgment, this intermediate court. And that is that the lower court never evaluated the mountain of evidence placed before it regarding the forceful capture, kidnap, torture, and extraordinary rendition of Nnamdi Kanu from Kenya back to Nigeria on the 26th of June, 2021.
Who are not educated. I am an educated man. I can't show them the petition for the simple reason that if you show it,
what the judge said was that the case file.
this is a federal gazetted law of Nigeria that says here that the chief judge of Nigeria cannot tell Binta Nyeko what to do. It's here. It's your law. Of Nigeria, chairman of board of benchers. A grown an old man like this doesn't know the law. You don't know the law.
I'll give you a petition.
Nobody wants to That's the problem. Corruption charges. They sent her to my case so they can release or smoothen the pathway for the husband and the son. They are facing. It doesn't matter if they off it. In a corrupt society, that's what happens. They are very, very corrupt. That is a breach of judicial oath. They have violated the judicial oath. They have shown bias according to Supreme Court. They are biased against me. Supreme Court said so. And that is why what is happening in the judgments and rulings concerning me has been happening. So, disobedience to superior court orders. Supreme Court said you are biased. You are against this man. You should not have revoked his bail. Nigeria went to Kenya and kidnapped him. These things are in the public domain. Why, therefore, are they insisting on trying me? A court order was entered. In that very court order, it was said very clearly and succinctly that she is no more. No. That she is no more going to try me. Why are they insisting? Why are they insisting? I ask. Because they have no case against me. They have no case against me, and they know it. I'm facing corruption charges. They sent her to my case. Bias according to Supreme Court. They are biased against the Supreme Court said so. And that is why what is happening in the judgments and rulings concerning me has been happening. So, disobedience to superior court orders. Supreme Court said you are biased. You are against this man. You should not have revoked his bail. Nigeria went to Kenya and kidnapped him. These things are in the public domain. Why, therefore, are they insisting on trying me? A court order was entered. In that very court order, it was said very clearly and succinctly that she is no more. No. That she is no more going to try me. Why are they insisting? Why are they insisting? I ask. You have made your point. Because they have no case against me. They have no case against me, and they know it. Supreme Court said, man, you should not have revoked his bail. Nigeria went to Kenya and kidnapped him. These things are in the public domain. Why, therefore, are they insisting on trying me? A court order was entered. In that very court order, it was said very clearly and succinctly that she is no more. No. That she is no more going to try me. Why are they insisting? Why are they insisting? I ask. You have made your point. Because they have no case against me. They have no case against me, and they know.
All right, guys, thank you very much for staying to the end of this news. So what's your take on this? Please, let's hear from you. Drop your comment below the comment section. Don't forget to give us a thumbs up. Please share this video, make it go viral. If this is your first time of joining us here, please subscribe to this channel. Thank you. See you in my next video.
They have violated the judicial oath. They have shown bias according to Supreme Court. They are biased against me. Supreme Court said so. And that is why what is happening in the judgments and rulings concerning me has been happening. So, disobedience to superior court orders. Supreme Court said you are biased. You are against this man. You should not have revoked his bail. Nigeria went to Kenya and kidnapped him. These things are in the public domain. Why, therefore, are they insisting on trying me? A court order was entered. In that very court order, it was said very clearly and succinctly that she is no more. No. That she is no more going to try me. Why are they insisting? Why are they insisting? I ask. You have made your point. Because they have no case against me. They have no case against me, and they know it.
We should have adjourned the case synergized. What's the way forward?
Well, there's no way this case could have gone on anywhere. Because in the first place, the court had lost jurisdiction to sit over this case since September last year. So we came here today on a limited appearance. We appeared on that protest out of utmost respect for the judge and for the court, to listen to the court as to the reasons why we were invited before the same court that was recused in September last year. Nigerian public needs to understand the nature of a recusal. A recusal comes as a court order, and even non-lawyers are aware that once an order of court is made, the only way you can sit to the side is to take it on appeal. Nobody appealed this order. The order is extant and subsisting, is still valid, and we were invited today to be informed about some memo from the Chief Judge that we don't even have a copy of the memo. So our submission on the record is that the court stands recused until that order is set aside.
No, sir. The judge, Justice Peter Yako, has adjourned this case. What is the implication for your plan?
Well, Senator is a word about for indefinite adjournment. So she has no business. The court, like I said before, even having the case before her today. So adjourning it, Senator or not, really, it doesn't apply. But remember that we had requested this adjournment last year, but it wasn't granted.
So what happens next?
Well, it's up to the judiciary and the federal government. We are not the prosecutor, we are the defense. You throw the ball to us and we catch the ball. We cannot reinstitute the case. Let them do the right thing. Our client recused the judge, and the judge consented to the recusal through a coroner. So we await the day that this case will be recalendared before a new judge to try it. We are not afraid of trial.